Hi, this is Steve Maag, Director of Assisted Living and Continuing Care at ASA. I'd like to talk to you about one of the issues that I frequently get questions on, and which also was a subject of an extensive listserv string a couple of weeks ago, and that is mobility aids in senior housing. By senior housing, I mean assisted living communities, CCRCs, and even independent senior housing. Mobility aids are generally considered to be things like wheelchairs, walkers, motorized or electric wheelchairs, as well as motorized electric scooters. Now, the first threshold question is whether the person that is using that device is actually impaired. For protection under the fair housing laws and disability discrimination laws, you first must find a disability. So if a person is using an electric device for simply convenience sake because they don't want to walk, that's not protected. That person wouldn't have any protections, and you could put restrictions on the use of those. However, the vast majority of cases, the people that are using those devices are in fact disabled and have some kind of a mobility challenge, and thus those become a reasonable accommodation and are protected under the provisions of the disability discrimination sections of fair housing laws. Now, there are a number of things which you can't do, which have been the results of court actions, complaints by the U.S. Attorney's Office, and settlements by providers. Some of the things that you can't do if you have somebody using a mobility aid are, for example, you can't have them have a driver's license type test when they move into the community. They are assumed to be able to use those devices, and you can't test them for their abilities when they move in. You also can't have damage deposits beyond the normal damage deposit that a regular resident of the community would have. You can't require them to have specialized insurance beyond the renter's insurance that you may require all of the residents of the community have. You can't screen people for medical conditions because they have a motorized cart, and you can't restrict access to any of the parts of the community. The theory really is that these people that have the mobility impairment need this device as a reasonable accommodation so that they can live and use and participate fully in the living environment in which they reside. However, there are still some reasonable restrictions that you can place. For example, if you have a crowded area in your community, such as a dining area where there is restricted access and the number of mobility aids makes it an unsafe situation or makes it difficult for residents or staff to access residents or serve, then you could have a restriction on the number of mobility aids in a dining area, or make arrangements such as parking them outside and escorting people into the dining area. You can institute reasonable rules of the road in a community for safety reasons, such as speed limits, stop signs, areas that are designated for the traffic of mobility aids, particularly electric ones. Lastly, and probably one of the biggest questions, is what happens if you have somebody who is acting dangerously with a power motorized wheelchair or electric wheelchair. First of all, you have to see some kind of objective evidence that they are a threat to the safety and health of other people. Once you have that documented, then you can begin to take steps to address that issue, such as making sure the resident is able to operate the wheelchair or electric cart safely by having a driver's test. You can put governors on them to slow them down, and you can do other things to restrict their access. Ultimately, if they really continue to act in a dangerous manner, you theoretically could prohibit them from using the electric wheelchair or electric cart, but that would be in an extreme case and as a measure of last resort. As always, if you have any questions, please feel free to give me a call or contact me via email here at ASA. Thank you.